you all to a webinar on data governance issues in current policy proposals. Today, we are fortunate to have two eminent speakers with us today. Professor Wolfgang Gerber, the Professor of Economics at the University of Marburg, and Professor Shrujani Sen, faculty at the National Law School. They are here today to share their thoughts on and bring more light to the discussions on data governance issues in current policies. And we are getting it from the perspectives of both the European Union and India. I would request all the participants to please put their questions on the chat window, and towards the end of the talk, we could address it to the speaker. So let me, without any delay, let me take this opportunity to introduce our first speaker of the day, Professor Wolfgang Gerber. He is a professor of economics at the University of Marburg since 1997. He was an inter alia Fernand Borel Fellow at the European University Institute and the Hauser Global Fellow at NYU Law School. His current main field of research are regulatory problems of digital economy, such as competition, data governance, and privacy. His most recent publications are about digital markets and privacy, interoperability, competition policy in digital economy, data governance, data rights, data access, data portability, and data trustees. He's also worked on access to in-vehicle data in connected cars, Digital Markets Act, the German Facebook case in competition law, and also the interplay between competition law and data protection law. I would like to invite Professor Wolfgang Gerber to share his thoughts from the European Union perspective. Over to you, Professor. We can see your slides, sir.
Okay. Yeah, thank you very much for this very kind invitation, and I'm very happy that I am at least virtually in India. I know that you also have in India a very interesting discussion about data governance and issues in different aspects. And there's also legislative discussion I have understood in India, and I regret that I don't know more about it, but I'm pretty sure that I will learn more about it in this event. So what I can contribute is talking about the European Union and about data policy aspects in the European Union. And now you all know that we have in the European Union for a long time already the European Data Protection Law for personal data. But since 2017, we also have an explicit European data policy also for non-personal data. So this is on one hand, this communication building a European data economy, where for the first time they really saw the problem that data are not enough reused and shared, especially also for innovation in the digital economy. And they have developed then from that also this the European strategy for data with a lot of initiatives. I don't want to go into this. But very important is now that there are a number of current legislative projects, and these are all very important and huge and perhaps also sometimes problematic legislative projects. So one is Data Governance Act, and very important, the Digital Markets Act, really about dealing with the huge economic power of the large digital platforms, then the Digital Services Act, and absolutely new now from February 23rd, the new proposal of a Data Act. So what I would like to focus on in my presentation about data governance issues is a bit about data governance issues in Digital Markets Act, but mostly I will focus on the data governance issues in the Data Act. Now, regarding the Digital Markets Act, I think most of you will know a lot about this. I only want to focus on specific obligations here, which are important for data governance issues. So you all know the Digital Markets Act is an ex-ante regulatory instrument, and it is now in the last phase really of getting enacted. So as I announced, the trilogue negotiations between Commission, Council, and European Parliament for really coming to the final version. But the basic idea was to have obligations, per se obligations for gatekeepers. And there are overall 18 obligations in the Digital Market Act, and some of them also relate to data governance issues. Rather famous is this Article 5a, that's about the prohibition about combining personal data from different sources without additional consent. This is about this data combination problem, and this is directly related to this German Facebook case. But very important is also, and also quite famous, Article 6.1j, which is about horizontal data sharing between search engines for enabling competition on search engine markets. So this is, as you all know, about Google search engine and whether they should really be obliged to share query and click data with smaller competitors. But I do not want to talk about these two, but about three other obligations, about a very specific data set, which is also interesting in comparison then to what is done in the Data Act. And these are the data obligations regarding data generated by business and end users on digital platforms. So the example is here, and there are also competition cases about this, that the Amazon Marketplace is collecting data about transactions between business and end users on their platform. And the decisive point is that Amazon, so the platform, has a de facto exclusive control over these data. And the problem is that these data are not made available enough to the business users who are generating them on the platform, and also to the end users. And that at the same time, Amazon can use these data for its own competition with the business users, because this is a dual platform, and therefore there is a competition problem. And now this is a very specific data set what we are talking about, and the data set is those which are generated by the business and end user through their transaction on the platform itself. And what the DMA is doing is changes the bundle of rights on these data, and this is a data governance issue. One article is the Article 6.1a, and this means that the gatekeeper is not allowed these data in competition with the business users, because this would give them an unfair competitive advantage and can lead to foreclosure effects. So it's a competition problem. And so what we see is with 6.1a is that it limits the rights of the use of the data. So they have the data, but they are not allowed to use them for certain kind of purposes, namely here competition with the business users. Then we have 6.1i, that's about data access for business users. And this means that the gatekeeper has to give the business users access to these data. And very important, this access is free of charge. It's also regarding aggregated and non-aggregated data. It's also in real time, and there are also interoperability requirements, so that's really effective. So that business users get a far-reaching right to access these data. And then we have 6.1h, which is about data portability. And this means that the business users and end users get a far-reaching data portability right on the same data. It's again aggregated, not aggregator. And very important also for the end user is also about non-personal data and also in real time. So the end users get a much more far-reaching data portability right than they're getting through the data portability right from Article 20 in European data protection law. So you see, this is a very specific data set, and the basic idea is that they get access to and can port their own data, and their own data because they have generated. And this now leads quite nicely to the Data Act and what the Data Act is really about. Now, the Data Act proposal, we have all long waited for it, and it's now published, 2 weeks ago. And so far, you find not very much about it. I try to give you a first kind of explanation and analysis of this, but this is very, very preliminary what I'm doing right now here. So it's basically about three main data governance issues. The first is about the governance of the data generated by Internet of Things devices, IoT devices. Yeah, and they give new rights to the users of the IoT devices to use and share these generated data. This is a new thing. And these are rules that are can apply the same way for B2B, so business to business context and business to consumer context. Then they have business to government issues about data obligations in a public emergency, and about switching between data processing services. Is about this problem of switching between cloud service providers. There are lock-in effects, and they try to solve these problems. So I will not talk about the second and the third issue, only about the third, really about IoT. And additionally, there are a number of general rules. So if legislators make obligations that data holders have really to make data available for whatever, then there are certain rules that have to be complied with, especially fair, reasonable, non-discriminatory terms, but also that the data holders get a reasonable compensation for these data. Then they have also rules about fairness of contractual terms in data sharing arrangements, especially for dealing with the problem of a very unequal balance in negotiation power. This is mostly about small and medium-sized enterprises. I will not talk about this. They have interoperability provisions in the Data Act, but this is only about data interoperability. It's not about technical interoperability. That's very important. And they make also provision that the sui generis right to database protection, which we have in Europe, and I think nobody else has this, should not be applicable to the sharing of IoT data. So, but I will focus entirely now on IoT devices and the governance of the data in IoT devices and what is changing through the Data Act. Now, if you look at the Internet of Things, you all know this, there are a lot of examples. Connected cars is one, smart TVs, other smart home devices, also virtual assistants, as for example, Alexa is covered by this Data Act. You have smart watches, fitness trackers, you have smart agriculture, and I think you all know the problem that there's smart farm machinery, and the manufacturers of the smart farm machinery, they are collecting all the data, and the farmers who are using this machinery, they have problems getting access to the data. There's a lot of discussion about this, smart medical products, but you also have a lot of smart machines within smart manufacturing. So it's also about governance of data using IoT devices within the manufacturing process and between businesses. So what kind of data are covered now by the Data Act with these rights? So this can be all kinds of data which are really generated by these IoT devices, so sensors, cameras, microphones, whatever. It's very broadly defined. But the rights only cover the data that are generated, not derived or inferred data. It is not so clear how you define it exactly, so this will be one of the problems in implementing this. Now, what are the typical problems that really emerge in IoT contexts? You can first look at the legal situation. So at least in the European Union, it is clear that many generated IoT data are personal data, and therefore they are very clearly subject to EU data protection law. And it's very important this is fully applicable also regarding to the Data Act. So the Data Act does not change anything with regard to the rights from European data protection law. Yeah, therefore often you need consent for dealing with this. But many of these data are also non-personal data. And very important is with non-personal data, at least again in Europe, that for non-personal data, as sensor data, for example, there are no rights. There's no property on these data. And therefore we had a discussion in Europe whether we should introduce some kind of property right, but this was rejected. So we are talking about data for which no formal legal rights exist, and there's so-called no de jure rights on this. But the data holders can have exclusive de facto control over the data. So the manufacturers are collecting the data, they have de facto control over the data, and because they can protect the data technically, it's economically very similar as if they would have an absolute property right on this, but only through factual control. Now, the main problem, and this is also then one of the starting points in the Data Act, is the following problem. We all know that the manufacturers of smart devices get the exclusive de facto control over all data that are generated by the device. This is where we start with. This is what they have done so far in the connected car example, in many other examples. And the problem now arises that the users of the IoT devices who somehow generate the data because they are generating it through the use of the device. You can also ask whether they are co-generating this, but it's very clear that they are generating the data, and usually we should not forget that usually the user is also the owner of the device, so has bought the device. And the problem is that these users cannot get access to these data. And also independent service providers who would like to use these data for offering services, for example, repair services, but also other services to the users, cannot get access to this data. And this also leads that these data are often underutilized, so not enough used. And this leads to problems for consumers, leads to problems for innovation, and leads also to problems for competition. Now, all these problems are explicitly acknowledged in the Data Act, and the Data Act should really help to solve them. Now, I would like to show this a bit deeper with an example. So I have worked a lot about data in connected cars and about data governance in the connected cars. And there is, since 2016, a controversial policy discussion in Europe about access to these data. And I would like to show you a bit the basic discussion about this and put this in the perspective of this Data Act. So what we have in Europe is that the car manufacturers, they have used the so-called extended vehicle concept as a data governance concept for their vehicles. And this means that all data that are generated in a connected car, so about driving behavior, technical data, about environmental issues, about traffic, etc., all these data are directly transmitted via a SIM card to an external server, which is under the exclusive control of the manufacturer, so the car manufacturers. And this gives the vehicle manufacturers exclusive control over the access to the data. And also, additionally, there's also exclusive control about the technical access to the car, because they design the product as a closed system, as no interoperability. And so the vehicle manufacturers get a gatekeeper position to the entire ecosystem of connected driving. It's not only the car, it's also all kinds of secondary markets. And this is a competition problem because they can foreclose independent service providers and can leverage market power to other secondary markets. And this leads to negative effects on competition, innovation, and consumer choice. There is a broad consensus about this. So, and therefore independent service providers have, and also consumer associations have demanded a regulatory solution for this problem since 2016. Now, what would be other data governance concepts for IoT? Another would be that the so-called shared server concept, and in fact, this is a data trustee solution. That would mean that also all the data are transmitted from the car to an external server, but this external server is not under the control of the car manufacturers, but is under the control of a neutral identity, a data trustee, who can then make these data available on a non-discriminatory basis to all stakeholders. The other solution, which is also very interesting, is the so-called open interoperable telematics platforms. And this is a different technological solution. This would mean that would imply that the data can be stored direct in the car, and the car users or owners have direct control about the data. So not the car manufacturers have control, but the car users have control about the data, and the car users have also control about the access to the car. So both solutions would eliminate this gatekeeper position of the vehicle manufacturers and therefore solve the problems. There was a study in 2017 in Europe commissioned by the European Commission, and they came to the result that both of these solutions would be superior to the extended vehicle concept of the car manufacturers. The European Commission has acknowledged this problem, but so far has not provided for any solution. Look what now the policy options are for this example of an IoT data governance system. So one solution for solving this problem of this extended vehicle concept with its gatekeeper position would be open interoperable telematics platform. This would be the introduction of a technological solution. The second solution would be a data trustee solution. I have worked on this recently with a colleague of mine. And the third solution, which has been mostly discussed, is a regulatory mandatory access solution. So that regarding the access to the data and the car. So the service providers, independent, would get directly access rights to the data and under FRAND conditions, so fair, reasonable, non-discriminatory, through a regulation. And this could be done in Europe through updating the existing type approval regulation for motor vehicles. And now the Data Act, with its solution of giving now new data access rights to the users, would be an additional possible solution. And we now look at the solution and then ask, can this work? So what is the Data Act now doing? The Data Act is now, it's about business to consumer and business to business data sharing. Now, Article 3, there are 4 important articles now. Article 3 is an obligation that the manufacturers have to design their IoT devices in that way that the data can be easily accessed. So here, products shall be designed and manufactured in such a manner that data generated by their use are easily, securely, and where relevant appropriate, directly accessible to the users. This is a design requirement of IoT devices. Then Article 4 is the right of users to access, where data cannot be directly accessed by the user from the product. The data holder shall make available to the user the data generated by its use of a product without undue delay, free of charge, and where applicable continuously and in real time. So this is the data access you, and they can use these data. And they have the right to share these data with third parties. Yeah? Upon request by a user, the data holder shall make available the data generated by the user of the product to a third party without undue delay, free of charge to the user, and of the same quality as is available to the data holder and where applicable continuously and in real time. So they can share the data with another service provider. Now, what does it mean? The design regulation of Article 3, making data access easily available for all IoT devices is a very far-reaching rule. Yeah, it also includes transparency about the generated data, because usually we do not even know what kind of data are generated in our IoT devices. And also who the data holder is, because he is the person who has made this data available. And very important for understanding the system, the data holder need not be identical with the manufacturer. So the manufacturer can have make contracts with another firm and who is then the data holder. Article 4 is the usage right. Yeah, so it's only necessary that the user gives a simple request, and then the data holder has to make the data available. The user does not have to give any further information for what he or she is using the data. Not necessary. The user also seems to be free how to use the data. There's one small exception, not to compete with the data generating device itself, and they have to respect trade secrets and data protection rights. Otherwise, they seem to be free. What is, however, unclear is whether the user has a right to get the data transferred, so it's a real data transfer, or whether they can only access them on a server under the control of the data holder. This is what is called now in the recent discussion in Europe, the so-called in situ data access rights. So the algorithms comes to the data and not the data comes to the algorithms. Now, the Article 5, right to share data, the basic idea is really for enabling additional services as repair services. And now, what are the obligations now of these third parties who then can use these data? So the obligations is the third party should process the data made available only for the purposes and under the conditions agreed with the user. So you have a contract between the user and the third party, and the third party should only use them according to this contract and shall delete the data when they are no longer necessary for the agreed purpose. Now, who can be third parties? This can be all kind of firms, non-profit organizations, even intermediation service providers in the sense of the Data Governance Act, but not. Very important, there's a provision, the firms that are gatekeepers in the Digital Markets Act, so we're talking about Google, Amazon, Facebook, Apple, they are not allowed to be third parties, so they should not profit from this sharing right of the users. Now the data can be used for all legal purposes. One open question where I'm not sure how to answer this, are the users really allowed to sell the data, for example, in the data market? I think this is not clearly here. It's not clear whether they are allowed to do this. Now let's again look at the relationship between the data holder and the third party. What because they have really to conclude a contract. Yeah. So the data holder and the party conclude, I would say, a kind of licensing contract about the data access. Yeah. And but the user has a right to define through its contract with the third party the purpose for what the data should be used in this licensing contract. Yeah. Important is that this contract between the data holder and third party now requires a negotiation between the data holder about the specific terms and conditions, especially about the fee. So the reasonable compensation. And they have to have a negotiation, and there's a specific dispute settlement about this. Now let's come to the analysis. The first analysis is, okay, we are talking now about data governance. So what about the data governance now of IoT devices? What has changed through the Data Act in comparison to before? Very important is the manufacturers of the IoT device, they can design the device, and through the technical design of the device, they can get de facto exclusive control over the data. But they do not get a right on these data in a formal sense. And then there's the data holders, which need not be identical to the manufacturers. They do also not have and also not get de jure rights on the data, but if you read this Data Act very carefully, then you see the position of the data holder is very much strengthened in this Data Act. So this is a de facto control, but the de facto control is strengthened to a number of provisions which are protecting this de facto control. And very important, the data holder, in our example now the car manufacturers, are entirely free to use the data of the IoT devices and can monetize them. Yeah, so they have the data, and what they are doing with the data, there is no provision that says anything about this. There is freedom of contract, and they can monetize them on the data markets. Now the users. The users can be very important consumers, but they can also be businesses. What they are getting, and they are the only ones who are getting here a right, they are getting an inalienable right, so they cannot waive it in a contract, an inalienable right to use these data and share them with others. But the users have no control over the use of the data by the data holders. Yeah, so they cannot control what the data holders are doing with the data. Now the third parties, very important, this can be all kinds of firms. Important is they have no direct access rights. So in that respect, the Data Act would like to give them more access, but not by giving them direct access rights. But they can access and use these data via request of the user, and that they are really exerting the data sharing right, and then they can use the database for frontline conditions, or they can also get access to the data by buying access from the data holders, because the data holders often will also sell these data, access to this data under free B2B contracts. This is what's about the assignment of the rights according to the Data Act. Now you can think about, can the Data Act solve the data governance problems in the connected car example? So we have seen our problem in the connected car as an example. And the point is, if you think this through, then it's very clear the vehicle manufacturers keep with the Data Act the exclusive de facto control of the data and can monetize them freely, no problem. And the Data Act does also not solve the problem of technical access to the car. There's no provisions about technical interoperability. And so the vehicle manufacturers keep their gatekeeper position with all the negative effects. Now, can the car users' rights now from the Data Act really mitigate these problems? Yeah, to some extent, perhaps, because they get a right to access data and share data with third parties. This can be a provider of repair services. Yeah, but it is very unclear whether this will work in practice. So the first point is, it is unclear whether the data that the users have the right to access are sufficient for really then allowing a service provider to provide its service. So they might be inefficient, not enough data, because it's only raw data and not inferred data or processed data. And there is no technical interoperability. So many services in regard to the aftermarkets and also in other markets will not be capable of being offered based on these user rights. And you have a very cumbersome negotiation process, which might have high transaction costs. So in that respect, the user rights of data will not solve the problems here. And therefore, one option is, and this is already discussed, that you need additionally a sectoral regulation, yeah, with direct front regulation of access to the data and technical access to the car. And this is again the discussion about the reform of the type appropriate regulation for motor vehicles. Now, what I've here, I'm nearly at the end. What I've here is a list, and it's a preliminary, incomplete list of problems of the Data Act, and there are many. Yeah, so many open questions. What is covered at all? And what these user rights really mean. Scope of data is not clearly defined. And really is this question, can users sell that data? I think this is a very important question. And whether this mechanism using only individual requests of users, is this really effective enough for making more data available to businesses for innovation and protecting competition? These rights might be much too weak for that. We have a very negative experience of the data portability right of Article 20 in European data protection law, which does not work. And this might also be a problem here. Then they are talking a lot about fairness. I have not talked much about this here, but fairness in the Data Act refers only to small and medium enterprises in business-to-business relations, but not to business-to-consumer relationships. So if you ask about the distribution of value of data between data holders and consumers, then this distribution is very asymmetric. The consumers do not participate really in the value of the data. One important question is also, this is a horizontal regulation with rules for all IoT devices, and you see they are very, very different, and also for B2B and B2C contexts. And it might be that this is too broad for one set of rules. And therefore, immediately comes up the question of sector regulation and what is the relationship between this horizontal and the sector regulation. There are other questions I don't want to go into. This is also only a preliminary list. I come to my last slide. The Data Act is, in my very preliminary assessment, a huge, very ambitious, and I am afraid also very difficult project about data governance in IoT contexts. And I am pretty sure it will be very controversially discussed. There are also a lot of deep conflicts of interest. So one is certainly between European large firms and US tech firms, so the GAFA, and this is one aspect. larger firms, smaller firms, but also between firms and the consumers regarding here these data. There are many unclarified questions, legally, technically, economically. So it's very important to have much more analysis and research before legislators should decide on this. They should be very careful about this. But very good is the main idea. And the main idea is really solving this problem of exclusive control over IoT data by manufacturers and data holders, because this is a real problem with a lot of consequences. And a good idea is empowering the consumers and making more data available for innovation competition. But I'm skeptical whether what they have done here with empowering consumers is enough really for achieving this. Many thanks.
Parvati, can start the other, right? I think the question answers are after this. We can't hear you. We can't hear you. I think you're muted.
I'm sorry. I was speaking on mute. Sure, we'll keep the questions in the end then. Thank you so much, Professor. I think that was an insightful talk. Basically, you touched upon an overview about data-related aspects of data policy proposals. You focus more on the preliminary analysis of Data Act. So taking forward or carrying forward this agenda of data governance issues in the current policy proposals, I shall request our next guest this evening, Professor Srijani Sen, to give us her thoughts from an Indian perspective. So introducing Professor Srijani Sen to our audience. After graduation from SIU in 2009, Srijani Sen began her career in McKinsey & Co. as a business analyst before completing her master's degree in law at Columbia University. She also studied from the School of International and Public Affairs, and she was subsequently a founding team member of the Vidhi Center for Legal Policy, where she led the public law team, and also created and ran an open resource digitizing and explaining Indian laws. Her research areas of interest are primarily on law, policy and technology, and also regulatory governance. I think you can take the stage, Professor Sen. We would be looking forward to your talk.
Thank you, Parvati. If you could just also share how long you think should I really speak for, so we have some time for discussion at the end.
Ma'am, I think you can take around 25 to 30 minutes, and then we can keep for Q&A, sure. We can leave another 15 minutes. Yeah.
Sure. Thank you, and thank you everyone for joining. Thanks especially to Professor Kerber. You know, I think as researchers working on these issues in India, we are always looking to grapple with the new texts coming out of the EU, and hearing an expert such as yourself really break down the concepts is enormously useful. So thank you, and I'll try to connect some of what you said to the developments that are happening in India. Though, you know, hopefully what will emerge from the end of it is that we're quite early in those discussions here. Can everyone see my screen?
Yes.
Yes.
Yeah, it's
sure. So much like Professor Kerber, I think could start with a very brief overview, which gives the context for particular discussions around non-personal data, but placed in the overall context of what's been happening in India. One thing I feel it's very important to understand right at the outset is that we don't really have much law on the ground today, which is actually in force on data governance. What we do have is a set of rules under our Information Technology Act. So these came in the early 2000s and were therefore based on the ideas came a lot from the 1995 European Data Protection Directive, which was the regime before the GDPR came into effect. And while those ideas, form the same kind of basis for protection of personal data and has evolved subsequently, the biggest challenges were in India were not the provisions of the law themselves, but mostly around the capacity to actually enforce it. because there was no specialized authorities or much specialized knowledge. It was the Information Technology Ministry and officers at various federal levels in that ministry who were additionally tasked with enforcing this law. So suffice to say that not much regulation of personal data actually happened. What data protection mechanisms were actually put in place? What happened as a result of the contracts that Indian companies signed with regulated entities abroad, mostly Europe. So India has a large number of IT services firms. These IT services companies would be handling the personal data of citizens abroad. And as a result of these contracts under which these cross-border data flows would be happening, they were required, because of the now GDPR regime, to actually put these data protection mechanisms in place. So some capabilities did grow in terms of data protection in the Indian scenario, but they happened not as a result of Indian regulations and Indian laws, but because of these contractual mechanisms that have been in place. Um, under these circumstances, what were the main impetus for government to kind of revisit this question and strengthen our own data protection regime? One was just the massive growth of the big tech companies in India. So India was rapidly becoming the largest platform for big tech companies, for them anywhere in the world. The growth of WhatsApp, Facebook, etc., meant that you really had to start thinking about the personal data of Indian citizens, and its control by a few large global companies. The second that provided some of the most immediate push to creating a data protection regime, but has kind of been lost in the conversation since, is actually the challenges that happened in courts to India's Aadhaar program. And the fact that the national ID program was collecting citizen data led to questions of whether that data would be adequately protected. And in the ongoing judicial proceedings, it was asserted by the government that a data protection bill was underway. That caused government to kickstart the legislative process. This, if I'm not mistaken, was about in 2017 or 2018, but we actually don't have that law coming in. So through the rest of my talk, I'll talk about briefly about what has been that journey of typically starting with an expert committee kind of exploring these questions, that turning into draft legislation, reaching parliament and the parliamentary processes. While the first half of my talk will be talking about these concepts, and particularly in the non-personal data context, in India, unfortunately, the questions of political economy become inescapable. So as much as this is to do with the specific provisions that are being brought in, a lot of this is looking towards the GDPR regime and learning from other countries. As much as it is about those specific concepts, it's also about the players in India today and what kind of influence they're able to exert. So whether it is kind of Indian startups, whether it is the big tech companies here, whether it is the government and its interest in kind of protecting Indian national interests, all of those questions do end up having a very large effect on what we eventually get as legislation. But right now, while there has been a lot of discussion and a lot of inputs and interest, we don't really have either a personal data protection law, and of course, the questions around governing non-personal data are even newer. So as at least the kind of draft legislation process reached Parliament, the government also turned to questions of non-personal data. And very much along the lines that Professor Kerber also talked about in the EU, as to who is getting the benefits of this non-personal data, whether it is being controlled by a few entities and is really preventing competition, preventing utilization of this data for the general good. So these were some of the questions that led to, first again, the commissioning and the release of a expert committee report on non-personal data, which was released just about 2 years ago, if I'm not mistaken, and then revised based on the feedback received from industry scholars, data protection and data governance experts. So that expert committee report is out there, and that lays out the broader context and how suggestions around how we should think about the governance of non-personal data, and of course questions around implementation, etc. Um, there has been some rounds of debate and discussion which has narrowed down these concepts, but I think as we'll see, the currently the kind of approaches that are being put on the table when it comes to data governance are very, very broad. Unlike Professor Kerber, who pointed out even now the lack of clarity around very specific aspects. So even if you're thinking about something like IoT data and access of a user to IoT data, things have been started a bit more in specific sectors. With at least the expert committee report on non-personal data, uh, this was defined very broadly. So it was potentially covering a large number of different sectors and data generated by different sectors. This is, of course, perfectly appropriate for an expert committee report to do, because it's just laying out the issues and not necessarily answering every last question as you would have in legislation. But that kind of lack of clarity and drawing strict borders around what they were talking about did lead to a very wide range of responses and not very clear goals for the way forward, right? So just to start off with, the first version of the expert committee report on non-personal data just defined this concept in the negative. So it said that if there is any data without personally identifiable information, that would be non-personal data. And then it talked about how that should, the economic potential of that should be recognized, and how that the sharing of that data should happen. So you can imagine that if just with the question of IoT data or a question of a particular kind of non-personal data, if so many questions can arise, then what will be the reactions of a wide range of industries or scholars, etc., on saying, what do you mean? Like, how would you intend to govern any data without PII, right? There were a few other qualifications, and as I said, there was a revised report later on as well, and that all of that did lead to some narrowing down. But originally, the report had clarified that it was two kinds of data that one should think about. First, data that had never related to any identified person, or data that was initially personal data but later anonymized. So it was talking both about anonymized data sets as well as data generated from, say, purely industrial processes, like data generated by airlines every time there's a flight, or geographical data or weather data, things like that. So those were the ways in which, again, very broadly, it understood this concept, but the overbroadness of this definition. And the other thing particularly pointed out by scholars and privacy activists was that in the real world, these lines are not so neatly drawn. So if you were going to be thinking of governing personal data and non-personal data separately, what actually happened was that there was a lot of intermingling of this data, or at different points of time, depending on how that data was handled, it could end up being personally identifiable or not, right? To give an example, let's say there is just a set of GPS information that exists with ride sharing platform, which is about my route that I take from my home to my workplace every day. It doesn't have any other kind of information with it, but it's just an anonymous person's route that they take daily. At that point, you could very rightly call it non-personal data, but with different commercial uses, if you were to combine that information from this ride-sharing platform along with financial information from somewhere else, or traffic cameras from somewhere else, that data could end up being created into personally identifiable information. So industry practices meant that the lines between personally identifiable information and non-personal data were very blurred. And that was, the second set of challenges. So you had one set of arguments by industry players that you had defined NPD too broadly and were looking at all kinds of proprietary information potentially under this. And the second was that, and this came from more the scholarly side of things, saying that, in regulation, you can maybe set out these different concepts, but in practice, you would find it difficult to regulate the two separately. This, to repeat, did happen because you were looking at the broad category of non-personal data and not something specific like data by electric vehicles or data from IoTs, etc. So there was some attempt, there wasn't a whole revision of this concept. So it did still understand non-personal data as any data that's not personal, but it did clarify that what it sought to do was not govern this entire universe of non-personal data, but only look at the kinds of data that justify regulatory intervention, which is data that can be used for the public good. This is not an objective standard by any means, and it seems like it would be up to some kind of public authority to determine what would fall under that category. But at least it does set out a regulatory approach. And then the next question, of course, is, okay, even if this is the set of data that you would be governing, what is it that you would actually be regulating? Right? So one early concern, and this is again more on the industry side, one early concern was that, is this going to be mandated data sharing? And then if so, on what basis? What is the legal basis for mandating this data sharing, right? Because, traditionally, if this is a company has invested resources in collecting this data, the understanding so far generally in law has been that it is the property of that company. And as these discussions were going on, and this is still very much at a conceptual level, whether something like an eminent domain in the Indian context would be appropriate was raised, but was also shot down quite quickly. So it wasn't seen as something which the government could have could assert any public interest over. And there were, of course, traditional intellectual property concerns. So the moment a company asserts that it has actually spent its skills on creating a data set, then it's even more going into the realm of being the intellectual property of that company, which you cannot mandate the sharing of. But much like the EU, the pushback to these traditional legal concepts comes from the assertion of the rights of the data source. So saying that you have to move away from the understanding that whoever is collecting the data is the sole owner of the data. If the data relates to an individual, then that individual has certain rights that we should recognize. Whether, particularly with something like non-personal data, can you really go back to the user? Is there a identifiable person who has the right to access or not? Often the answer would be no. So to go back to my kind of GPS movement explanation, I may be unaware that my route was being captured and later on used in this way. So you cannot really come back to me to ask, and for me to assert my rights that that data be shared with other competitive ride sharing platforms, right? So while they use the language of rights and thought about the rights of the individuals or the sources of the data, it would often be some kind of third party acting on my behalf. That could be government itself, a government saying that, Indian citizens' data is being used in this way, and so I shall act on behalf of Indian citizens to govern the data in this way. Or it could be these new mechanisms that are also being placed on the table, like data trustees, looking at community-based organizations, etc., to say that there would be these entities that would act on behalf of the data sources, but are non-profit founded or various other kinds of entities, but they would act on the behalf of the individual whose data it originally was, and assert those rights and enable this kind of data sharing primarily for the benefit of those individuals and those communities. So this has been, I saw a common thread there, that at the very basic level, the justification for any of this kind of data governance goes back to asserting the rights of the source of that data, but always actually being able to identify that person or tie it back to the consent or request of that person is a big challenge, again, if you consider the realities of what these data sets look like today. So that's why it's kind of an imperfect answer even today. And some of the suggestions that happened during the discussions around this was perhaps you need to think of an entirely new basis in the law to justify this kind of regulation or intervention around non-personal data. To build a little bit more on the communities and custodians ideas there, this was found to be of a lot of interest because India was among the first few countries which in a government document had recognized this concept. And this again sought to address that challenge of not always being able to go back to the individuals whose data this is, but to think about representatives or trustees of this data and to have them participate on behalf of the users that we are talking about, right? So the report conceptualizes that there would be community organizations or data trustees which would exercise these rights on behalf of the community. And this is very certainly an interesting idea that merits further exploration. But right from the start did raise questions around who represents a community, the identities involved, and whether you are top down kind of creating institutionalized mechanisms that may not actually reflect how these communities behave, what they think about the data they generate, etc. So an interesting idea, and much like the whole data governance conversation, just something that becomes clearer in the detailing of it. To do all this, as I hope was clear from the beginning, we don't really have any particular specialized regulator to deal with either personal or non-personal data. And so this expert committee report on non-personal data had clarified the role of a regulator, particularly because it was unclear initially on how the government itself would intervene and how much it would just enable the unlocking of the economic potential of this data. So that's why the report actually broke it down into these two different concepts. One, what are the sorts of things it would merely enable, not mandate? And two, what are the kinds of things it would enforce? So where would it order certain activities, whereas where would it do a more facilitative role? Right. So it said that there would the report originally said that there would be a non-personal data authority. This kind of specialized expertise is actually really important in India because, as I said in the beginning, we do have certain data protection laws, but they are as good as defunct because you don't have the dedicated regulatory resources under them. And so with any of these questions, the immediate kind of policy question one has to grapple with is, okay, but who's going to enforce all this? And more often than not, in the last 5-10 years, the answer has been to propose a new regulator who's specialized in that particular area. And the expert committee report here did recommend the creation of a non-personal data authority. Its enabling functions would be ensuring that at its core, it would unlock economic benefit from non-personal data for India and its people and communities, right? So very much, again, a response to the growth and competitive advantages and centralization that was happening with the big tech companies in India, and the concern that the data generated by Indian individuals and small Indian businesses was not flowing back to the Indian economy or its people. And that has been one of the core impetuses for the whole thing, and something the NPDA would be tasked with as well. Right? So, and to do this, I think the expert committee report envisaged essentially a consent-based data sharing framework. So just facilitating the creation of platforms where two consenting entities could easily come on board and exchange data with one another. So again, to go back to a kind of mobility example, if you had various generators of non-personal data, as well as companies or researchers or anybody else who would benefit from this data, the fact that this data exists would be made known on this data sharing framework. And whoever was interested in accessing this data could then, under controlled circumstances, with things like data protection, maybe the consent of the original creator of the data, and the economics all being worked out quite easily on the data sharing framework. And of course, this not needing further justification because it was based on the consent of all the relevant entities. Where it was a pure non-personal data that didn't relate to any individual, it would just be the source of the data and the buyer of the data. Whenever there was an individual concerned, then mechanisms are being thought of where that consent of that individual would also be obtained in this data sharing framework, and the all the provisions around the protection of personal data would also start kicking in those circumstances, right? So this data sharing framework, and this would be a facilitative role by the government, was one of the things imagined for the NPDA. The final thing was about just the discovery function. So knowing that this data exists and having that understanding that it could be used in all these manners. And so the report first defined a data business and said that we will facilitate again the creation of a metadata directory of data businesses, such that it is known that these data sets exist. These are their prices or conditions under which they can be shared. And these are the ways in which it can actually be used to kind of go back to the goal of unlocking economic benefit. So this is still all fairly at a high level, but this was the way in which it was imagined. But this wouldn't be enough. So this isn't only a purely consented mechanism that the government is just enabling. It also wanted to establish rights. So what I said about asserting the rights of Indian citizens on their behalf, saying that there is such a thing as Indian non-personal data, and the NPDA would establish what those rights precisely were, and how they should be thought about when it came to all the data businesses actually dealing with Indian data, right? The NPDA would also then look at questions of privacy and data protection, like the very important question of anonymized data sets and its particular re-identification through various processes, and preventing other kinds of misuse. So just the data that was shared on a consented basis, the controls over that data and that exchange also being taken care of by the NPDA. And the last thing it mentioned, which is potentially cause for the most pushback from the industry, is a narrow subset of possibly mandated non-personal data sharing, right? So let's say if there is a data request and that request is refused, then this report did imagine that there would be some kind of an adjudication where on a case-by-case basis, the authority would decide whether the custodian is right to refuse to share the data, or whether there would be provisions in a legislation that would mandate that that data be shared. So in this final set, you might end up having the kinds of provisions that Professor Kerber was also talking about, saying that, okay, for the IoT context, if a user requests data of their own from an IoT provider and the IoT provider refuses, then and that is something that an authority can adjudicate and decide on. So it is mandated data sharing, but it's not mandated data sharing for everything. It's mandated data sharing for certain categories of high value data sets. So it's interesting that they kind of chose the nomenclature of a high value data set because it's not then necessarily about the rights of citizens or potential harm that comes out of the non-sharing, but really narrowing down on that concept of its economic potential to the Indian economy, and that being the basis for when an NPDA will say that this kind of data sharing is mandatory and this kind is not. So that is the concept that it's taken up for now, while other ideas, I think, would have also contributed to this effort. But the few key takeaways from this is one, that the regulator and its powers was really central to making any of this happen. And that regulator was imagined to have both a facilitative role as well as a mandatory and adjudicatory role. There has been a lot of discussions overall in the country around whether it's a good idea to keep having new regulators. The specialized capacity and focus that it brings in is certainly welcome, especially in new technical areas where the industry is evolving far faster than government can always keep up. But it's also meant that there are multiple regulators and it's hard to draw up their jurisdictional boundaries very clearly, which has meant that both for a regulated entity as well as for the regulators themselves, there is overlap, there's friction, and overall the burdens of regulatory compliance go up. And so this did propose a creation of a new entity, but the questions of harmonization certainly existed at that point. And so where are we now from all of this? As I mentioned in the beginning, the Personal Data Protection Bill had reached Parliament. And so there was a parliamentary process going on at the same time as the Non-Personal Data Expert Committee report came out. And so both of them were actually considered together, the bill as well as the policy proposal for a regulation of non-personal data. And a committee report was ultimately issued after a very long process where closed door discussions were had with all kinds of stakeholders, including notably all the big tech companies. And it, unlike the original report, very clearly recommended that you should have a single bill, a single act, as well as a single authority that governs both personal and non-personal data. So not to look at personal data, not personal data separately, but the expertise that you would need and the questions that would arise, it would be most appropriate for one framework legislation and one authority to deal with both. Partly because of the problem I'd identified at first, saying real world data sets don't neatly always distinguish between personal and non-personal data. And second, just friction of two different regulators and two sets of regulations itself. This certainly deserves merit, and a lot of scholars have been critical of this proliferation of different regulators. But it must also be recognized that the main policy goal of these two governance regimes are almost at odds with one another, right? One is about the protection of data, thinking about the privacy rights of the individual. So it's about actually not sharing data as much as possible. Whereas with the non-personal data conversation and the governance scheme, that is about actually data sharing. Might be about protected data sharing and having that happen in a safe and secure way. But overall, one set would be concerned with as much data sharing as possible, and the other might be more concerned with shutting it down. Perhaps it's best for those interests to be located within the same regulator and not be at odds with one another. This kind of a debate had actually been considered both by the expert committee, which had kind of arrived at a different answer. The original expert committee had said that the DPA, the Personal Data Authority, would be focused on the prevention of personal harm, whereas the any kind of NPDA will focus on unlocking value in non-personal data, right? So saying that the goals of these two would be at odds with one another, but now the push very much is towards unifying these two policy proposals. That was where we were at a few months ago, but the very latest kind of development on this is that following the deliberations in Parliament and the closed door deliberations in particular, and again from newspaper reports, it seems like following the pushback from big tech companies in particular, the current bill has been found to be a non-starter. So there are reports at least that that entire journey for the Personal Data Protection Bill itself may be scrapped entirely and things being drafted from scratch. That leaves a lot of things in a great deal of...
Hello, I'm so I have titled like these notes.
Sorry. Let me go ahead. The current version and everything we were talking about did depend on the texts that we had and the policy proposals that we had.
All right.
And there might be now a completely new conceptualization. What does seem quite clear is that I think in any new version, they will be looking at both personal and non-personal data governance and starting to narrow down and focus on particular kinds of data and how those should be governed. So we're still very much at a kind of conceptual level, though there will be more legislative developments, I think, in the months to come. I'll pause there, and I'm very happy to hear any questions or enter into any discussions.
Well, thank you, Professor. I think that was indeed thought-provoking for us, where there were various categories of data adopted in policy papers and legislations, the introduction of proposed data governance regulatory framework, and even finally the ways in which greater agency and respect for individual and community rights can be incorporated into existing frameworks were dealt. So I again, as a reminder to the audience, please put your questions on the chat window and I could ask them on your behalf. To start off, there's a question. The question of who owns the data after it is collected is in a flux, especially the non-personal data. So what in view of each of you, that is Professor Shrujani and Professor Kerber, on who should be the primary owner of the collected data? The argument against individual ownership says the amount of processing required in such case will create huge costs for the companies, making the use of data financially non-feasible. So either of you could take it first.
Okay, if I should start, I don't know. Do you want?
Please.
Okay, I mean, this is also the topic Professor Sen talked about. Who should be the owner of the data? And I think a very important starting point is that we should understand that in the end, if we talk about data, about non-personal data, personal data is different, but about non-personal data, this is a non-rivalrous good from an economic perspective. And therefore, it is not at all clear whether there should be one sole owner of the data at all. And the question is exactly what is the right governance structure, the right bundle of rights on these data, because several can use it at the same time from an economic perspective. And I also have understood this was a starting point of the whole discussion also in India about non-personal data, that these data should be made available to as many innovators as possible. This for creating here economic value and innovations. And therefore, I think we make a mistake asking about the question and making this comparison that we should have a sole owner of data in the same way as we have as there's a sole owner of a private good as a car or something, because a car and a private good is a rivalrous good, and therefore we might need a sole owner, but not in the sense of data. So in that aspect, there is a principal difference, and this is one of the big difficulties of the whole discussion.
Well, absolutely. I completely agree with that, because there is an assumption in that question of ownership, which is that all those rights then vest with the owner, and it's unquestionable, right? So, and the very interesting idea of a bundle of rights instead means that you can start thinking about unbundling it or having one right over the same data set be given to several parties, right? So whether it is on the sharing of the data, the control, the processing, disposing, etc. It just doesn't make, and this is not true for data when it comes to many other kinds of community rights, let's say over community land or the commons. These kinds of things have been discussed before, and it even more easily, I think, lends itself to the question of data. The reason why it may not be gaining as much traction is because it is in the interest of the current controller of the data to think about it as ownership, but it is not definitely not necessarily the only way forward.
Thank you, professors. I think there's another question saying, my question is for Professor Kerber. The Data Act covered derived and the Data Act covers derived and inferred data. What do you actually mean by derived and inferred data?
I have mentioned derived data. So there is a difference between raw data that are directly generated, and then you can analyze these data with data analytics and using software, and then you are getting derived data or inferred data from that. And there was always an important discussion that the aspect of making a sharing data should primarily focus on the raw data and not on the derived data, because the derived data, you have an investment of the firm who is now analyzing the data, and so should be rewarded somehow. So the basic idea was making this distinction. It is not so clear whether this is always so clear what is meant exactly by this. Yeah, but it's clear that the data sharing discussion, and this is also true for the IoT discussion here in the Data Act, say this is covering this user right about sharing is only covering the raw data. It's not covering the inferred and the derived data. Yeah.
Okay, I think there was just a disturbance there. Sure. So if I can go on to the third question, is there a measurement framework available, like an index, to measure the health of data governance in an ecosystem, like the Indian smart cities ecosystem? What might be the different themes to measure the effectiveness of data governance in a particular context?
I think that's a really interesting question, and I'm not aware of anybody who's attempted to do it in a single framework. But if I can suggest some factors, I think it would go back to the primary goals and look at those goals and see what are the indicators of the kinds of uses or flows of data that are happening against those goals, right? And so whether it's the protection of personal data, where if you just look at kind of industry practices, data businesses and their practices around the protection of personal data, that gives you a sense of how much this is being done. Of course, aggregate data on this is not available, but you do have reports around how much compliance happens with the data protection side of things. On the data sharing side of things, again, an indication therefore would be, do you have many non-personal data sharing mechanisms with high volumes of activity? So do the networks exist? Is there sharing happening on those networks? And is that happening in a consented, secure way? And there also, it's quite clear that we're at very early stages, right? There's just it's starting up, and you have to see whether it picks up or not. But even when it comes to, there's consent of two parties and data is being exchanged, just infrastructural challenges, like knowing that those data exist, is it in a usable form, the way in which one company has created this, is it usable by another company, formats, etc. All those infrastructural challenges seem to be holding us back more than the absence or presence of regulation. And so there are very real concerns about, will you over-regulate and kind of kill this, given that there's so much more to be overcome as well. So some of those are indicators of the health of the system, but it hasn't been done in a very systematic way as far as I'm aware.
So I also would agree with this, and I would perhaps complement this a bit from an economic perspective. So we in economics, we usually talk about market failures and ask about whether, for example, and this is a discussion really also in the connected cars, if really the competition on secondary markets, for example, aftermarkets, does not work anymore, then you have a competition problem. So you have a market failure problem. And then what you can do is you can now talk about data rights. Yes, this is what the Data Act is doing, but you can also ask whether the competition policy should correct this directly. So this is why we also have data access obligations from competition law. So you can also in competition law have remedies which share data for solving a competition problem. In the same way, you can think about innovation and what are really hurdles for innovation, because you have an unhealthy data governance, if you want to express it in that way. And important are also the objectives you have. That's exactly what you said. And I think with regard to smart cities, this is a very complex problem, because you have also very different kind of objectives, what you want to achieve. And therefore, it's exactly a multi-dimensional problem, what health is here.
Thank you, professors. Any other questions? I think I've asked all the questions that the audience have asked. If anyone would like to raise their hands, I could call out their names and you can direct the questions to the speakers. Okay, so we are running out of time. So, ma'am, I will request Professor Anjula Gurtu for her last thoughts on the webinar.
Is that okay? Should I just go ahead? So, okay, so I'm again questioning. I'm going back to the same question of data ownership. Just a thought, and I would like to know what your thoughts are, Professor Sen as well as Professor Kerber. Now, the fact is that the whole concept of public data and private data, non-personal as well, is getting any personal and private. The whole issue is getting very blurred. Right? And in data itself, that is happening because a lot of government data, for example, is getting collected by private entities. Right? And so in a concept where you know that the whole concept of public and private is getting very blurred, and saying that there's a clear distinction is putting it very simplistically. And this also includes data and other things as well. In a structure that is emerging like this, do you think all data should actually be a public good? What if I was to say that put all data as public good and the whole exchange should be not economic? I mean, as a private company, let me use the data to generate an app which will be helpful for my business, but to buy and sell that data let it not get into an economic exchange. What would be your views?
Now it's a difficult question for me as an economist. No, so the problem is I know the discussion a bit in India, so I also have read this report, and I know they're using this term public good. We don't use this in that way in Europe in the same way, but I understand what you mean, and I would like to make an example. So you have seen these data in connected car discussion. And there was one solution. This was putting these data of the connected cars under a data trustee, the governance of a data trustee. And this might not be so far away what you are thinking about. So I wrote a report with a colleague of mine, a law professor, and we thought about the option also putting all these mobility data, yeah, that are really now generated through these millions of cars in Europe and in Germany, whether putting these mobility data under the governance of kind of a public institution, and this public institution as a data trustee, and this public institution makes these data available under certain principles for certain objectives, also about public interest objectives. So that both the service providers can get access to the data for their services for competition, but also that, for example, public institutions can get access to data for traffic regulations, for environmental problems, etc. And we are not so far saying we would recommend this, but we are far enough to say we should really analyze this option, whether it might be a good option, alternative option. Yeah, and therefore, I think this might be not so far away what you are thinking.
Okay. Thank you. What do you feel, Professor Sen?
Actually, it is difficult for me as well as a lawyer, because, with the concept of public good, and, if we were to think in an ideal world of a trusted anchoring of that, a data trustee, which works on not on economic principles, but on principles of benefit to the community, etc. That is certainly of value, and it's a really important thread to hold through this, right? The thing is, with thinking about this as an economic good, ultimately you have a very easy mechanism that is consent based. So if you have rights of various stakeholders articulated, I'm not even saying there's one owner, but several kinds of rights are recognized. And again, this is also wishful thinking, but that consent can be gained in a not a very cost heavy way. Then you do have consent based sharing or consent based utilization. And if you don't, then you are saying that ultimately one entity is deciding on how this data should be used. So you may be therefore narrowing down this decision making to particular kinds of entities and trying to govern them, which down the line leads you down to the same set of challenges, like you're trusting the trustee.
Yeah.
So you're not actually ultimately trying to decentralize these kinds of questions, and not saying, look, I don't pretend to know about, like, tomorrow's data sets and data questions can be completely different from today's. You can either place faith in an institutional mechanism, say, okay, this is a public good, here is the trusted entity that now treats it as a public good, but you're then trusting them for the future. Whereas if you go back to consenting, saying that, okay, here are the principles by which people can get together, but we're recognizing certain rights that have never been recognized before, then that is perhaps a more sustainable way of doing this. So I can imagine like all sorts of critical papers being written about data trustees, and the recent kind of UPI, NPCI conversations have also led us to think about it in the financial technologies concept. So it was given all the limitations around financial transactions and open networks, it was very much believed that some kind of new entity with a heavy government presence, but not entirely a government presence, would be the best place to anchor this kind of shared network protocols, etc. But then this is also then the entity that can single-handedly set market rates, add people to the network, kick them out, etc. So yes, calling it a public good, but then you do lead to decision making being concentrated a little bit more. I think that's not an inevitable next step, but it's often the next step that happens.
Yeah. No, thank you so much. This is really interesting. This kind of a two spectrum thing, not exactly on the other ends, but it was really interesting. Thank you so much. This is really nice to hear.
My pleasure. And thank you, Professor Karwa. It was lovely hearing you.
Thank you so much.
From our side.
I think the time ran out pretty fast. We were like 1.5 hours went out in a jiffy. So I think with that, we come out to the conclusion of this webinar. I would like to extend our heartfelt gratitude on behalf of the Center for Society and Policy and at IUDX to both Professor Wolfgang Graeber and Professor Srijani Sen to have taken out their time to address this very pertinent topic to our August gathering. I definitely had a good time listening and a lot of research ideas. And thank you so much once again. And I hope our participants also felt the same. Looking forward to meeting all of you very soon for the very next webinar in the days to come. Thank you so much once again to all of you. Wishing you a very happy weekend. Bye-bye.
Thank you so much.
Bye. Thank you.
Thank you so much.
Same process, but thank you so much.